So for the first 100 years or so of our communications system, there was a requirement, and the webcasting conversation got very legal, so I'm going to try really hard, even though I'm a lawyer, to try to keep it as simple as possible. So the first 100 years of our communications system, the on-ramps to that system were required by law not to discriminate against any traffic, and that was called common carriage at its basic, okay? So it didn't make a difference whether it was Scott or me or somebody with a lot more money than the both of us combined making that phone call. That phone call had to go through at the same quality of service, all right? So it's just the on-ramps to our communication system. We're not talking about regulating the Internet, the applications, the services, the content on the Internet. We're just talking about regulating the on-ramps. Well, things started to change a bit in, it was 2002 or 2003, when the cable industry, which had started their cable modem service, wanted to know how that service was going to be regulated. Was it going to be regulated under the same regime that their cable television is regulated, which is a regime that, as I said before, gives them an awful lot of control as to who gets on and who gets priority? Would it be regulated more like the telephone system? Would they be required to make cable modem service available, again, on a common carriage basis? Or would it be something totally different, something called an information service, which the FCC can regulate but generally has not? So the FCC decided that it would be an information service. Was this 2003, right? Harold, you can help me on that as well. Well, thanks to Media Access Project and others, this case went to the Ninth Circuit. It actually went in two cases, but I'm not going to get into those details. The court actually reversed the FCC's decision to call it an information service and thereby not require it to comply with common carriage rules. But then the Supreme Court re-reversed the decision. So, and this was in 2005. Summer of 2005, the Supreme Court said that cable modem services could be classified by the FCC as an information service, and therefore did not have to be subject to this non-discrimination principle I talked about. Several months after, I believe it was September 2005, the FCC decided that since those rules would no longer apply to cable modem service, they would no longer apply to telephone company provided broadband services. So it's really been a little bit about a year and a half that we've been fully operating under a regime where the telephone companies and cable companies could discriminate. Now, Scott will tell you that they haven't, and there's no evidence of a problem. But if you recall, right after that decision in late 2005, that's when the net neutrality forces started to get very, very vocal. So it would be absolute political suicide for the telephone companies and cable companies to discriminate. So they've been on their best behavior. But even if they weren't on their best behavior, I think you have to ask yourself this question, and then I'll stop. Isn't the principle of openness important enough to have it apply regardless of whether there is evidence of a lot of blocking and discrimination? There's been some evidence, not a lot, a handful of instances. Isn't the principle that important that we should want it regardless and not wait for the toothpaste to come out of the tube?